I'm coming. I've had to endure so much.
I have hope that someday the right individuals will be charged for my mom's murder and put behind bars forever.
There's still information to work with. It's clearly a cold case, but Jason has been asking for additional investigation for a long time. It's hard to say if there will ever be a conclusive answer. It would be very hard to prosecute someone because the defense in that case could say, well, you've already said you had probable cause that it was someone else. But it's possible.
My dad had the headstone made without my name on it. So it's hard to go there and visit and take our kids. And our kids, you know, they kind of still scratch their head to this day.
I believed that the truth will set you free. But I'm going to tell you that that's not always true.
Friends and family say that Bill Carter has attempted suicide more than once in the wake of Shirley's murder. In an interview, Bill stated, quote, "The worst time is when I wake up in the morning and I reach across the bed and she's not there." To this day, no one else has been charged for that crime. I'm Tamron Hall. Thank you for watching Someone They Knew.
Tonight on Closing Arguments in Portland, Oregon, romance thriller novelist Nancy Brophy on trial for the murder of her husband today. The victim's mother revealing details of the day her son was killed. Is this evidence of a murder most foul?
It was a very matter-of-fact thing. It was Dan. I was absolutely devastated.
In Minneapolis, Minnesota, 22-year-old Amir was shot and killed by police executing a no-knock warrant in February. Now, officials announced there will be no charges against the officers involved. The think tank weighs in.
This is a slap in the face to not only this mother and family, but to all of us.
On the docket tonight in Fairfax, Virginia, we're gearing up for the trial of Johnny Depp versus ex-Amber Heard. Depp is suing Heard for defamation. Heard is suing back. Tonight, we'll dive into the text messages Amber says prove Depp is violent.
It has been incredibly painful to relive the breakup of my relationship, to have my motives, my truth questioned.
Plus, the defense says it's likely Nancy Brophy will take the stand. So tonight, we ask you, the 13th juror, how crucial will her testimony be, given what we've seen so far in the case? Buckle your seatbelt. This hour of Closing Arguments starts right now. Good evening and welcome to Closing Arguments. I'm Michael Ayala in tonight for Vinnie Politan. And we begin tonight in Portland, Oregon, where romance author Nancy Brophy is on trial for the murder of her husband, Dan. On June 2nd, 2018, the body of Chef Dan Brophy was discovered at the Oregon Culinary Institute where he taught. Now, he had been shot twice, once in the back and once in the chest. Today, Dan Brophy's mother testified for the state. And look, folks, there are a lot of things that can throw even a seemingly perfect murder plot off the rails. Usually, it's the cover-up, the after-the-fact slip-ups that criminals make trying to cover up their crime. Well, something like that may have happened today in the romance novelist murder trial. I want you to listen closely to the testimony of the victim's mother. She described a series of phone calls between herself and Nancy Brophy. She tells the jury about Nancy calling and telling her Dan had been shot and killed, revealing what could be a key piece of evidence for the state. Take a listen.
Tell us what it is that you remember about what Miss Brophy told you during that third conversation.
That Dan was shot and killed.
Did she tell you how she knew that?
No. I guess I assumed the police had told her that.
She didn't elaborate on how she would have known that before she talked to the detectives?
No.
And even after reviewing this email, do you recall if there was anything else that was said during that conversation?
I don't believe so.
Okay. And once again, what was her tone and demeanor like during that conversation?
She said it was Dan. It was a very matter-of-fact thing. It was Dan.
All right, so I hope you didn't miss it there. The implication being that Nancy Brophy had information she could not have known because she had yet to talk to the officers. We'll check in on that in a minute. Let me bring in Court TV legal correspondent Julia Janae. She's joining us live from Portland, Oregon tonight. All right, Julia. All right, direct exam. It did seem as if Karen Brophy said that Nancy told her Dan was shot and killed before she could have spoken to detectives and found out that information. That would be very damaging stuff. So how was it handled on cross?
That was the suggestion by the prosecution, that she may have already had that information that wasn't released. But the defense did not just let that linger in the air from this testimony. Lisa Maxfield on cross-examination questioned whether or not the timeline that was given was really firm. It's the goal of the defense to discredit the witness and especially the witness's memory. Here's how she did that on cross-examination.
So your second call was made at 10:44. Would it surprise you that Ms. Brophy began her recorded interview with the police at 10:47? You know, when it comes to the time,
Sure.
I'm not a young person anymore.
You're doing
So
great.
therefore, right, I cannot specify time.
Okay.
So really where it was left, even after not only cross but redirect, is that it's possible those 3 calls that Karen Brophy said she made to Nancy, one where she was learning that something was amiss, and the second call where she encouraged her to actually go down to the crime scene, or the scene at the time where her son was, and then that third one is the one where she seemed to have this additional information. The defense suggesting that she was right with detectives when she made that third call and likely already understood that someone had been shot and killed and that it was in fact her husband.
Yeah, well, I wonder if they dodged that bullet. I'm not 100% certain. Online, people still seem to think there was a gotcha moment. All right, Julia, now the jury also heard from another employee from the Oregon Culinary Institute. What did they have to say?
Right, Maxine Bartashane, she appeared via webcam. She was someone who was in Portugal, so she could not appear live inside of the courtroom. But she was a key witness for the prosecution to talk about what Nancy Brophy was saying in those moments when, according to the prosecution, she had killed her husband and then returned home to seem unaware of everything that had happened. This witness actually called her and let her know what she was understanding, because she worked at the Oregon Culinary Institute with Dan Brophy. She got a news alert on her phone letting her know something was amiss at the location. And she said that Nancy told her that Dan wouldn't have told her if something was going on at work. He would probably wait until he got home. This was a witness that, though she was talking about or being used by the prosecution to show some inconsistencies, she was also good for the defense because she talked about their marriage and how good Nancy spoke of her husband. Take a listen to that moment.
From time to time, did you have conversations with Nancy Brophy in which maybe you not so much complained but groused a little bit about Dan Brophy?
I tried not to, but probably once or twice. I mean, I don't think it's fair necessarily to complain to one spouse about another spouse.
Okay. But if you did grouse a bit about Dan, or maybe you were present when other people did, how did Nancy Brophy react?
Oh, she always was his greatest defender. She always defended him. She always came up with a reason that he was okay. Always.
And you hear the witness, voice there cracking just a bit. It was an emotional moment inside of the courtroom, even coming through that stream. The defendant at this point, she's nodding. She's looking at the jury and she's nodding, saying, yes, that's how I was with my husband, confirming that she always defended him. She also took this moment to take her glasses off when this witness was testifying, to look at the webcam and just make sure that she was making that eye contact, even though she wasn't there live in court.
Yeah, it was an interesting testimony for sure. Now, Julia, the jury also heard from one of the responding officers who noted Nancy's behavior at the scene. Tell us a little bit about that.
That's right. Officer Cassandra Wells was someone who responded to the scene. She was there at the Culinary Institute before Nancy Brophy would have arrived to be told by authorities what happened to her husband. She said she met her in the middle of the street, and that when she learned the news that this woman broke down crying and that she actually hugged her in that moment, seeming to show that there was some genuine grief going on from the wife. The defense also used this witness to bring out something that was a little bit interesting on cross. They asked her if she noticed anything different about how Nancy Brophy looked inside of the courtroom today. And it is something we've noticed, that she does look different than some of the pre-trial hearings that she was present for. I think we have a look at a side-by-side of those two. She asked if you noticed that she looks like she's lost weight. Not sure what the defense wants to suggest when they got this officer to talk about it. The officer said that she really didn't notice one way or the other that she could have lost a little bit of weight, but it is very noticeable to us that she does look much thinner than she did many months, 2 years ago.
Julia, I also want to check on her behavior in court. That's Nancy Brophy I'm speaking of. We had heard that she was doing a lot of staring at witnesses, staring at various people, even some reporters. I want to check and see if you found that to be the case today as well.
So, Michael, I was on guard for this because Court TV's Matt Johnson reported on that a couple of days ago. Yesterday, he was saying that she had locked eyes with him and it seemed to be unnerving. So today, I was the newcomer inside of the courtroom. I was watching how her eyes lit up when she saw the supporters when she first came into the courtroom. Even though she was handcuffed, the guards were taking the cuffs off of her. We don't show that on TV per the court's order, but she was very upbeat, very chipper in the courtroom. And then she scanned the courtroom, seemed to notice me, and I could feel her eyes on me, and she was not breaking her stare at all. I eventually looked away, but it is something that Matt noticed when he was here, and now I am seeing the staring. She is seated in a different manner today than she was on previous days. She sat in a way where she could be in the line of sight of the jury. Didn't see that much today. She was more facing the witnesses and the judge.
All right, interesting points there. And finally, Julia, I believe the state ended the day with the lead detective. What was your takeaway from his testimony?
Right, Detective Anthony Merrill, he laid everything out for this jury. He's the lead detective on the case. He brought out the diagrams. He brought out the entrances and exits of this crime scene. The real takeaway, I think the prosecution wanted to hit home for this jury, is that he saw no signs of forced entry. He didn't see anything disturbed. Even pointed out the wallet of this victim, Dan Brophy, that still had its credit cards in it, still had cash in it, his keys. A pocket knife was found on his body that he had not disturbed, so seemingly didn't use in any way to try and defend himself against whoever the assailant was.
All right, Julia Janae, thank you so much for that report. Truly appreciate it, as always. I'll let you go now. I want to bring in my think tank for tonight. Joining us from Atlanta, Georgia, criminal defense attorney Eklund Mercy. Great to see you, Eklund. In Los Angeles, California, former federal prosecutor Nima Rahmani. And in Phoenix, Arizona, the attorney who represented Jodi Arias and the author of the book series Trapped with Ms. Arias, Kirk Nurmi. Thank you all for being with me tonight. It is certainly my honor to have you on the show. And Eklund, I'll begin with you. Obviously, the big issue tonight and something, as I mentioned, that really I thought viewers, at least from what they've expressed online, have really touched a nerve with them. This idea that mom testified to what appears to be, or might be, a gotcha moment, that this defendant said something she shouldn't have said. What do you make of all that?
It's just facts. I think that, unfortunately, you know, the phrase that comes to mind is that art, like life imitates art far more than art imitates life. And we have a novelist here who's probably just very creative, very, you know, extra, and may not have given the performance that anybody else would want her to give. And I think that that's a dangerous place to be at. Like, the gotcha moment, but I believe that with the officer kind of cleared that up, saying that, hey, she was definitely emotional when she got the news. And, you know, it could be like a couple of minutes with regards to how she knew about the shooting, but I don't think a whole case would lie on it, personally.
Interesting. Kirk, I want to get your take on it because I think Eklund is right. I think there certainly was some rehab there based on that testimony. They got mom to admit that time, and she's a little older. Time could sort of be a little bit of confusing for her as well. And also, there was a small sense that I got from her that she was sort of catering her testimony because she was very upset at the defendant. Your thoughts on that whole thing?
Well, you know, I think Eklund hit the nail on the head to some degree, but I think that gotcha moment still sticks, right? What, you know, we hear, like you said, a lot of people online reacting to that. I think that's still going to stick in the jury's head because it's easy to understand, and it becomes just another circumstance to advance the state's case, which is entirely circumstantial. So they're going to have to do a better job, I think, moving forward. And we've heard the idea that she's going to testify. You know, that was signaled in the defense opening. She's going to have to. That's going to be right now. That's going to be the number one thing she's going to have to explain when she takes a stand in terms of when she knew, because it just looks bad. That's not the kind of gotcha moment that just evaporates quickly. It's going to loom over this whole trial until it's cleared up.
Nima, what do you make of Momgate? I mean, do you think it's something that's going to stick in the jurors' head? Did the defense do enough on cross to make it clear that this was a confusing situation with a number of calls in succession, and what was said when was not something Mom could really pinpoint?
Yeah, I agree with Eklund and Kirk on this one. It was a good moment, but the defense did a good job of unwinding it. So, and I knew it wasn't going to be the state's best witness, because normally if Mom, a grieving mother who lost her son, was going to be the best witness for the prosecution, she would be the first witness. But instead, the state put on the culinary students that found Dan's body. But I agree with Kirk. Ultimately, this is going to come down to Nancy's testimony entirely. Was for her book, and the fact that her van was caught on camera near the scene of the crime. This is a circumstantial case, and she better have a very good explanation as to those two key pieces of evidence for the state if she has any chance of acquittal here.
Yeah, no doubt. Her whereabouts at the time the van was seen in the area, but we do have, you guys will be staying with me. Now, when we come back, no charges will be brought against the officers involved in the death of Amir Locke. We're going to have more on that coming up next, so keep it right here.
is a slap in the face to not only this mother and family, but to all of us. And we pledge out of National Action Network at our national convention that we're going to the Justice Department to review this case. There cannot be the allowance of no-knock laws nowhere in this country, whether it is this case or whether it's Breonna Taylor. It's all because we're dealing with states' rights legislation around no-knock law. This young man was in his own home, laying down with a licensed gun, and he is killed. And their defense is self-defense. How do you defend yourself in my house when you don't have a legal right? The warrant did not have his name or apartment there. What are you defending yourself against? Breaking and entering into my house? So it must be federal law. And we want her to know that we're going to stand with her and go to the Justice Department and demand they review this. This is not over.
Welcome back. That was Reverend Al Sharpton at a press conference earlier today reacting to the news that there will be no charges filed in the death of Amir Locke. If you remember, Locke is the 22-year-old who was shot and killed in February while the Minneapolis SWAT team was performing a no-knock search warrant for someone else. The incident was captured on body camera video and was released not long after the shooting. Take a look. After reviewing that video, along with all the other evidence, Attorney General Keith Ellison, along with Hennepin County Attorney Mike Freeman, released this statement today saying there is insufficient admissible evidence to file criminal charges in this case. Specifically, the state would be unable to disprove beyond a reasonable doubt any of the elements of Minnesota's use of deadly force statute that authorizes the use of force by Officer Hanneman. He goes on to say that it would be unethical for us to file charges in a case in which we know that we will not be able to prevail because the law does not support the charges. Now, while no charges are being filed for Amir's death, there are changes being made to the Minneapolis Police Department's policies. Yesterday, Minneapolis Mayor Jacob Frey announced that he has formalized a new policy that will take effect Friday, requiring officers to knock and wait before entering a residence. All right, let me bring back in the think tank to get their take on these developments. Still with me, criminal defense attorney Eklund Mercy, former federal prosecutor Nima Rahmani, and the attorney who represented Jodi Arias and author of the book series Trapped with Ms. Arias, Kirk Nurmi. Kirk, I want to start with you and get your reaction, and I'm going to go around the horn and get everyone's reaction. But first, I want to start off and get your reaction to this decision not to press charges.
Look, ultimately, we heard from Reverend Sharpton, who I shared the disdain for no-knock warrants with, but I cannot agree with his contention that there should be a prosecution in this case. Because when we get to the point where the officers are in this apartment serving this warrant and there is a gun pointed at them, the question becomes, what were they supposed to do? What are they supposed to do in that situation, if not protect themselves? And the Reverend seems to think that, there should be prosecution simply because somebody was shot. And I just do not believe that. The real crime here is the no-knock warrants, and those need to be pulled back. But the idea of pursuing this with the Justice Department still doesn't get past, to me, that question of what is the officer in that situation supposed to do? I don't know that we can hear a reasonable answer to that question.
Yeah, fair enough. And the Attorney General said it's not their job to consider at that time if no-knock warrants were appropriate. Eklund Mercy, what's your response?
I'm disgusted because here's the thing. When does prosecutor's office do offense and defense? That defense, that's a defense. If there's self-defense, that's a defense that should be brought up at trial. So at least let the jury exonerate the officers. Let the jury, let the citizens have a chance to have their say with regards to the facts. The fact that we have a prosecutor who's considering a defense, so now we have prosecutors who are only about convictions and not about the people. Let the people decide. That's why jury selection and jury duty is so important. I don't believe that this was a right call. I do believe that, hey, if there's a defense, then let the officer present a defense and let the people decide if he's guilty or not. But for the prosecutor to take that on by themselves, yeah, I do not agree with that.
All right, Nima, I'd love to get your response to that. It's an interesting argument. In these times, perhaps it may make sense, but your thoughts on it?
I agree completely with Attorney General Ellison's decision here. And let's not forget, this is a brave, just, and aggressive prosecutor who prosecuted Derek Chauvin, charged the other 3 officers, a lot of prosecutors would not, and charged and convicted Kim Potter. So this isn't someone to shy away from prosecuting officers. But in this case, and setting aside what you think about no-knock warrants, oftentimes the officers executing the warrants have nothing to do with actually getting the search warrant. And that's what happened to Breonna Taylor. They're just doing their job. They enter the residence like they're supposed to, and someone grabs a gun. They really have no choice under the circumstances but to shoot. This was the right decision by the Attorney General's office. Obviously very tragic that Amir Locke had to die. That death was completely unnecessary. But this isn't a situation that merits criminal prosecution, Michael.
You know, what I'd like to do now, guys, is I want to actually take a look at the Minnesota statute for when an officer can use deadly force, as it was referenced in that statement. Now, according to the statute, for a peace officer's use of deadly force to be authorized, there must be at a minimum a threat of death or great bodily harm, which, 1, can be articulated with specificity, 2, is reasonably likely to occur absent action by the law enforcement officer, and 3, must be addressed through the use of deadly force without reasonable delay. And also it says the law does not allow for consideration of the victim's subjective intent. So Eklund, I want to go back to you. As far as those 3, in terms of proving those in court or disproving them, the only one that I can see that maybe they could have some issue with is number 2. Was it reasonably likely to occur? That means the deadly force, absent action by law enforcement. They did see a gun come out from under the blanket. Perhaps there was a time frame there. They could have waited a little longer. But of those, where do you think the opportunity for prosecution lies?
The issue is a no-knock warrant. You have a no-knock. You got in without a knock. At that point, somebody could yell police or something. When you just run through because you want to go in blazing saddles, that's the problem. At one point, you have to let you know, because all he's seeing subjectively and objectively is lights. All he's seeing is lights and black people that are masked coming into his home. That a reasonable, prudent person would also have the same reaction. We can't say, hey, we have the right to bear arms, but yet and still I can't use mine. When you make a mistake, at one point, they have to, there's like 6 of them in there. At one point, somebody could have yelled police or showed him the warrant. That wasn't done. It's like, what do we do? It doesn't even make any sense.
Yeah, I mean, clearly it's safe to say that Amir Locke would still be alive if it wasn't for no-knock warrants. So there have been changes. Let me go over a couple of those. These go in effect on Friday. Police must knock. During the day, they must wait 20 seconds before entering. At night, they have to wait 30 seconds. There's no-knock warrants have been abolished, basically, unless they're very extreme circumstances. Civilians will be able to review the video. So the question for you, Kirk, is, does that go far enough? Is that the right direction? Because a lot of people will say, especially in the law enforcement community, that puts them at even more risk.
Yeah, you know, it seems like it's a compromise between these 2 opposing forces, and that's ultimately what happens in a democracy, right? We believe in the beauty of compromise. Personally, I believe that no-knock warrant should be abolished simply because of what we see here in Mr. Locke. And I want to advance what Eklund said. Mr. Locke did nothing wrong. He reacted appropriately within his home. Could a knock have prevented this? Maybe. Could that 20 or 30 seconds, whatever would have been appropriate during the time frame, would that have altered the course of events? Maybe. So it's a step in the right direction. I personally would still like to see no-knock warrants abolished, but ultimately this is a step in the right direction, and it is a compromise that serves competing interests, because we certainly don't want a situation where law enforcement officers are put in jeopardy either.
Nima Romani, quickly, in the last few seconds, your take on the changes to the no-knock warrant laws.
Yeah, I mean, first I gotta say, I heard police announce themselves several times in the video. And then no-knock warrants aren't necessary. This was a murder investigation. Okay, this isn't some misdemeanor offense. I mean, there was a reason that law enforcement was going in there. And obviously, Breonna Taylor, you use no-knock warrants in drug cases, otherwise the drugs disappear. So maybe limit them, but I don't think they should be abolished entirely, Michael.
All right, fair enough. Think tank, stand by, please. We do have to take another quick break, but here's a look at what's still ahead on Closing Arguments. On the docket tonight in Fairfax, Virginia, we're gearing up for the trial of Johnny Depp versus ex-Amber Heard. Depp is suing Heard for defamation. Heard is suing back. Tonight, we'll dive into the text messages Amber says prove Depp is violent.
It has been incredibly painful to relive the breakup of my relationship, to have my motives, my truth questioned.
Plus, the defense says it's likely Nancy Brophy will take the stand. So tonight, we ask you, the 13th juror, how crucial will her testimony be, given what we've seen so far in the case?
Johnny was hitting me, and he was hitting me hard and repeatedly.
Johnny Depp versus Amber Heard.
This is going to be one of those big trials to watch.
You have these big celebrities that are going to be testifying.
Their reputations are at stake.
Johnny Depp was not successful across the pond, but he's got a second bite of the apple, this time in the United States.
Johnny Depp versus Amber Heard. Live coverage starting Monday morning at 9/8 Central on Court TV.
We are just days away, folks, from the start of Johnny Depp's defamation trial in Fairfax, Virginia. The actor is suing his ex-wife, Amber Heard, for $50 million over an op-ed that she wrote for the Washington Post in 2018. Depp claims the op-ed falsely implies he abused her. Depp even claims it was Amber who was physically violent with him on occasion, which came up in a 2016 deposition.
One time, Johnny was hitting me, and he was hitting me hard and repeatedly, and I was screaming. Security walks in, and they don't do anything about it. And he makes this motion when Jerry Judge yells boss, or Sean, I can't remember who it was. And all we had was a little bit of separation, and my sister runs down the stairs. We're on a landing in between two flights of stairs.
Ms. Heard, I must interrupt you because I've asked you a yes or no question.
Withdraw your question then, because she's answering.
Ms. Heard, prior to today's date, have you ever hit Johnny Depp?
Answer however you wish. You've already asked, and she's already answered, and you interrupted her.
Ms. Heard, have you ever hit Johnny Depp prior to today?
Objection, Vegas to time.
Everyone on this side of the room, please.
Objection 352. It's not relevant to the domestic violence proceeding.
Overruled.
Thank you, Your Honor.
Answer it however you want to, including the way you were just...
I'm asking for a yes or no answer.
You don't have to answer it the way she wants you to answer it.
He was about to push my sister down the stairs. She was attempting to break us up. I am protective over my baby sister. When he laid hands on her, I don't know what I did, but I know I jumped in between the actions that I saw could lead to a fatal injury to my sister. She was standing on the top of a flight of stairs, and she has never hurt anyone in her life, and she does not deserve to be pushed down the flight of stairs. And it looked like she was about to be. And I would have done what anybody who has a child or a sister would have done. I acted defensively in her life. I saw her standing on top of a flight of stairs and trying to interrupt a fight in between him and I. I don't know what part of my body I put in between me and him and her. But I would have done anything. I would have done anything to prevent her from being pushed down a flight of stairs.
Amber Heard filed a countersuit claiming Johnny Depp defamed her by calling her a liar and a hoaxer. And in the countersuit, Heard's attorney cites specific text messages allegedly sent by Johnny Depp to friends that indicate his intentions to ruin her career, harm her, and kill her. Let's take a look at a couple of them. In 2013, Mr. Depp texted his friend, actor Paul Bettany, the following: "Let's burn Amber. Let's drown her before we burn her. I will blank her burnt corpse afterwards to make sure that she is dead." And in 2016, Mr. Depp texts to his friend Christian Carino, "She's begging for total global humiliation." Depp goes on to call Amber a number of vulgar names before finishing the message with, "I wouldn't touch her with a blank glove. I can only hope that karma kicks in and takes the gift of breath away from her. Sorry, man, but now I will stop at nothing." Heard's attorneys write, This is only the tip of the iceberg, reflecting Mr. Depp's misogyny, deep anger, and hatred of Ms. Heard, and his attendant justification in his mind of his violence and abuse towards Ms. Heard. All right, let's bring in the think tank to discuss this. Still with me, Eklund Mercy, Nima Rahmani, and Kirk Nurmi. All right, Nima, I want to start with you. Those were just a smattering of the text. There are plenty of them. They get ugly. I believe they definitely show misogyny, hatred. I mean, it's pretty nasty. Your thoughts on these texts and what effect they may have on the trial?
Yeah, the texts are key. I mean, that deposition testimony, wow. I mean, you're talking to a former prosecutor who's now a civil plaintiff's attorney. And it was so nasty that they actually had to bring a special master, a referee, to handle that deposition because even the attorneys can't get along. Now, Johnny Depp's already lost his defamation suit in England. The standard is much easier for plaintiffs over there. That's why these defamation attorneys file there. Now he's here in the United States. We have First Amendment protections. The burden is on him now to prove the statements were false. Whereas the burden's on the defendant over there in Europe. So you're talking about someone who's either getting bad legal advice or throwing good money after bad. Maybe he's trying to resurrect his acting career somehow. But I predict it's going to end terribly for him, and he's going to lose this case, Michael.
You know, Kirk, the thing about text messages is, you know, and we've all been there, somebody will text you something. It's all about context, right? And as a friend once told me, you can't impart tone on a text, you know, but texts they're a part of life now. It's how we communicate. They're going to be a part of these trials. We've seen it time and time again. Your take on text and how you deal with some of the texts that we've seen here and even worse.
Well, you know, I think you're right when we talk about these text messages. Context is going to be key in framing any case. If any party is going to emerge victorious here, they're going to have to provide context for the things they said, because I don't really think that either party is going to come out looking great in this situation. So, you know, it's going to be salacious. But that's going to be the problem for both parties as well, because the salacious nature might just do away with all the context that surrounds it. And what a jury's going to make of all this grade school level fighting with adult words is going to be very interesting, because that's really what we're talking about here. We're talking about a grade school cafeteria food fight that's going to play out in a courtroom.
Yeah, but you know, this thing got really ugly. It got pretty serious, at least according to the allegations. Eklund, you saw that deposition. You saw the woman there, and there are accusations that she was also involved in domestic violence both ways in a previous relationship. Johnny Depp has a tough job, but she also has a countersuit. Do you think she has the horses to win her suit? The fact that obviously she's a liar and a hoaxer, she has to show she wasn't a liar and a hoaxer, because that's what she's claiming Johnny Depp is calling her. So what do you think about that?
I actually think that her the text messages actually hurt her case. To say that the text messages between friends. Now, here's the thing. It's so funny. I think John Mulaney has a joke about this. It's so funny. The worst text messages I've ever seen haven't been on my criminal cases, the murder cases, the aggravated assault cases. It's actually been the civil cases, the divorces, because what they say about each other and what they say about people that they don't like with friends is just, it's crazy, but it's cathartic at the same time. So I think with this case, it's all about jury selection, 100%. People who are familiar with divorces, people who are familiar with like nasty child custody cases. That's the type of jury that you want, because they'll be able to sift through all the dust and actually see the case for what it is.
That's a great point, and that's exactly what you're going to have to get across to them. The idea that when you're texting these things, they're not really something that you actually mean. You're talking to a friend, and that's what I mean by context, et cetera, et cetera. I think any of us would be horrified if people were going to take a look at some of the texts that we send to our friends in various circumstances. The thing, Nima, that I wanted to check in with you is, you know, he's suggesting that she was doing this just to further her career. And again, this was brought, and this whole thing came up during the Me Too movement. It was a big thing back then. But that's one area where I think it's pretty weak. It doesn't seem to me that that holds water. She would do all this and put herself through all this just to further her career. I would think there would be better ways to do that.
I agree, Michael. And look, she's not the one that initiated any of this in terms of the violence, at least according to her. But from a legal perspective, she didn't sue him. Even the counterclaims here were because he filed against her here in the United States. And the op-ed that she published, she tried to do so anonymously there in New York. So this wasn't someone who was going out there and trying to get a lot of attention about her being the victim of domestic violence. So I don't think that's a good argument. And again, I see a case where Johnny Depp, even though he's the civil plaintiff, he's going to be on the defense, and it's not going to end well for him.
Yeah, I think I might have to agree with you there. All right, guys, stand by. Quick reminder, Court TV cameras will be inside the courtroom for this trial, which is set to begin next Monday, coming up April 11th. And lead anchor Vinnie Politan will be live in Virginia next week as this trial gets underway. Right now, folks, we do have to squeeze in a break, but when we come back, it'll be time to hear from you, our 13th juror. Keep it right here on Court TV.
Nancy Brophy will testify, and much of what I share with you this morning, you will hear from her directly. The state suggests that Nancy Brophy's life was going to get a lot better when Dan was gone.
They're wrong. Nancy was lost after Dan was killed. Her friends will tell you that she sounded very confused. It was as though the earth had fallen away from her feet.
Welcome back. That was defense attorney Lisa Maxfield during her opening statement, letting the jury know that the defendant, Nancy Brophy, will testify in her own defense. So today we posted to our social media pages and we asked you, the 13th juror, how crucial will Nancy Brophy's testimony be given the evidence that we've seen so far? And we begin, guys, with our 13th juror comment of the day, and that comes from Cindy, who says, at this point, it doesn't matter. When the victim's mother stated that the defendant called and told her that her son was dead before the cops even called her, that proves she's guilty. All right, Think Tank, I want to get your thoughts on that, because as I mentioned earlier, folks are taking that moment to be something more than I think it was, or maybe I'm the one that's sort of wrong here. Kirk Nurmi, your thoughts on this idea that she is going to take the stand, and I get the sense from her, she's one of these people who thinks she's a little smarter than everybody else. I wonder if you think it's the right thing for her to do.
Well, yeah, Michael, I get the same sense in terms of she's thinking she's smarter than everybody else. Plus, I also notice she's sitting there at the table, her defense team is masked and she's not. That tells me that she's enjoying her time in the spotlight, that she's caring about her image, she's glaring down court TV reporters, she's monitoring coverage, that sort of thing. And I think that sort of attitude can convey to the jury. But I agree with you and disagree with Cindy to her point. I don't think this is quite the gotcha moment that a lot of people are making it out to be, but it is a big, as I said, big cloud over this trial. And I think she's going to have to clear up her image, what she's projecting in court, and she's going to have to clear up this particular fact. So that's why I think it's crucial when she takes the stand that she clears both those things up.
All right, let's go on to our next comment. It comes from Power Surge on Twitter, who writes, Nancy Brophy will say Dan's mother was incorrect, and Nancy told Dan's mom after she talked to police, regardless. Nancy seems like the I'm smarter than everyone in the room, there it is type. She has stared down jurors, people testifying, and others in the courtroom. Her lies take her down. Eklund, this guy seems to have it all pegged. I mean, that would really mirror the types of thing that I'm thinking about this trial. I'd love to get your thoughts.
Well, first of all, the victim wasn't 12. So, of course, they're going to tell his wife first, and the wife is going to find out first. And a lot of times you don't want to give the cold call to the mom because, hey, I would prefer to tell her myself versus an officer to tell somebody. So I think maybe that could have been an issue. So I think depending on how the defense words the closing, but most importantly, she's a creative. She literally writes plots for a living. So she's not going to be a normal person. You know what I'm saying? So like the artist types are going to take everything in. This is happening in real time for her. So I can see why it may look different for somebody, but if you know artists or creative people, this is kind of normal. She's just taking it all in because that's just what they do for a living.
Yeah, that's a fair point. You know, again, that's something they're going to have to get across to this jury. Let's go to our next comment from Donna. She says, can't wait for her to take the stand. The state is going to have a field day with her. Nima, before we get to that comment, I want to check in with you on this idea of the defense attorney, Lisa Maxfield, telling the jury right off the bat that she was going to take the stand. Obviously, it's a big part of their case, but I wonder if you think that's a good idea for defense attorneys in general, even if that's something they plan to do, making that commitment that early on. Do you think that's a good thing?
Well, the traditional wisdom is that it's not, and this is something that's changed over the past couple decades I've been practicing. Before, criminal defendants would rarely testify because they get torn up. And even if they did, there's no way the defense attorney would announce that in opening statement. They probably wouldn't even announce it when they started their case in chief. It would be one of the last, if not the last witnesses. So now they're committing, and now she's got to testify. And I agree with Donna, the state is going to have a field day with her. And this is why we talked at the top of the hour of all the circumstantial evidence that's going to come in the gun, internet searches in the vehicle. But one important fact, one piece of evidence that's been excluded so far that I think will get in during cross-examination because it's relevant to impeachment, and that blog entry that she posted, that how to kill your husband, it's excluded now, but I think the defense is opening the door, and once she takes the stand, all bets are off, and they're going to be able to ask her about it, Michael.
Yeah, and it'll come in, again, there are mitigating factors with that article. Not sure how probative that is, but it is certainly something to consider. All right, guys, I really want to give a big thanks to you guys for coming on tonight with me, Eklund Mercy, Nebo Ramani, and Kirk Nurmi. Always a pleasure to have you on the show. Coming up next, we're going to step aside for a quick break, but at the top of the hour, we're going to bring in our investigators and take a look at some new developments in the case of missing 4-year-old Cody Bigsby. All that and more when we return.
.023.
In Hampton, Virginia, the search continues for 4-year-old Cody Bigsby, who was last seen in late January. Cody's father, Corey, back in court and denied bond.
He done nothing wrong.
Do you believe he's a risk to the community?
He's not a risk to the community. He's been there here all this time.
In Anne Arundel County, Maryland, officers save an infant and a toddler from a car in a pond. We have the heroic video.
Are you able to come pretty set far? I got her. I got Fred. Got her.
In Minneapolis, Minnesota, 22-year-old Amir was shot and killed by police executing a no-knock warrant in February. Now, officials announced there will be no charges against the officers involved.
This is a slap in the face to not only this mother and family, but to all of us.
Buckle your seatbelt. This hour of closing arguments starts right now. Welcome back to Closing Arguments. I'm Michael Ayala, in tonight for Vinnie Politan. The search for 4-year-old Cody Bigsby has been ongoing since his father, Corey Bigsby, reported him missing in late January from their Hampton, Virginia home. Now, Corey told police he woke up on the morning of January 31st and his son was nowhere to be found. Corey Bigsby has been identified as a person of interest in the disappearance of his son. He has been charged with 7 counts of child neglect stemming from incidents prior to Cody going missing and unrelated to this case. He appeared in court Tuesday and was denied bond. Penny Mitt from our great affiliate WTKR has more on this story.
Tensions and emotions very high inside of the Hampton courtroom today, where Corey Bigsby, the father of missing 4-year-old Cody Bigsby, was denied bond. But that decision did not come quickly. It came after over an hour of arguments. Now, no cameras were allowed inside the courtroom, but we can show you some footage from that initial bond hearing. If you remember from back in February, Corey Bigsby was denied bond after it was discovered he had an AWOL conviction in the military and was said to be a flight risk. Well, that was discussed again today, with Corey testifying that it was due to a miscommunication between his higher-in-command and following a 4-day weekend when he was job hunting for life post-military. Commonwealth attorney Anton Bell then discovering Bigsby was actually gone for 3 weeks and in the United States for part of the time he was supposed to be in Germany. Anton Bell also noting Corey Bigsby's previous assault and battery charges in 2018, as well as the possibility of obstruction of justice. Bell argued if Corey is released, he may try to tamper with evidence related to the disappearance of his son, Cody. Combine these 3 arguments, and Judge Savage, who you may remember was brought in after all of Hampton's judges recused themselves from the case, denying Corey Bigsby bond, saying he's a flight risk and a risk to the community. We caught up with Corey's aunt after court.
He done nothing wrong.
Do you believe he's a risk to the community?
He's not a risk to the community. He's been down here all this time and ain't harmed nobody.
Also discussed inside the courtroom today, the mishandling of Corey's interrogation by Hampton police and the FBI. Bigsby's lawyer, Jeff Ambrose, recounting hours of interview footage from the days leading up to Bigsby's arrest, stating that Bigsby was in HPD custody for 72 hours, despite not technically being under arrest, and after asking over and over again if he could go home. 62 of those hours were after he asked for an attorney and was ignored. Jeff Ambrose also described evidence that Corey Bigsby was denied sleep, was told to put chairs together to use as a bed, and was psychologically pressured. From Hampton, Penny Commit, News 3.
All right, let's bring in tonight's guest. Joining me in Salt Lake City, Utah, private investigator Jason Jensen. In San Diego, California, retired director of the San Diego Police Department Crime Lab, Jennifer Shen. And in Hampton, Virginia, Commonwealth attorney Anton Bell is with us as well. Thank you all for being with me tonight on the show. Anton, I'll begin with you. We're in that courtroom today. It was all about that hearing and that bond hearing. But before we get to that, I want to start off. During that hearing, you did mention that Cody is missing and presumed dead. Any updates at all you have? I mean, that's what this is really all about. It's about Cody and finding him, figuring out what happened to him. Any updates at all on the search and investigation into his disappearance?
Well, first of all, good evening, Michael. What I can share with you is that so many avenues were exhausted concerning the search for Cody. He is a 4-year-old who, according to his father, disappeared in the middle of the night and just went outside in the snow. And there's no evidence to confirm that or even to corroborate that. And as you can well imagine, that was back in January of 2022, January 31st. We're now here in the first week of April, and there's absolutely no signs of him. It's just in legal law enforcement, when we know we go this long and there has been absolutely no sign of a life of the person in which you're looking for, particularly at this young age, there is a tendency to believe that that person is deceased, and everything right now that we have found thus far is pointing in that direction.
All right, now today's hearing, let's get to that. Some of the things that were argued at that hearing were outlined in that piece that we saw, but I want to check in with you. And you made the arguments that he should not be released. You talked about the seriousness of the charges. You talked about some previous charges, also some issues with the armed forces as well. Outline some of the things that you argued as to why Corey should not have been released into the community.
So under Virginia law, when you are determining whether a person is eligible for bond, there are several factors that can be taken into consideration. The two main factors are whether that individual is a flight risk and whether that person is a danger to the community. And so the defense obviously tried to offer to the court that Mr. Bigsby was not a flight risk or was a danger, and they tried to bring up his military background and his career, stating that he had a stellar career. I was able to obtain his military history, and I was able to show the court through his military history that not only did he not have a stellar career, but his career involved the AWOL, and it was at the very, very end of his career. And so they allowed him to go ahead and retire. However, during the evidence, it was shown that instead of this individual saying that there was a miscommunication with higher ups and it was only a 4-day weekend, he was actually missing for more than 3 weeks. And while they thought that he was in Germany, where he was stationed, he was actually back in the States in New Jersey and had been there for quite some time. In addition to that, when talking to his commanders, he stated that he was currently in Germany with his wife celebrating I believe it was a birthday, and the facts from that AWOL hearing showed or determined that he actually caught a flight from McGuire Air Force Base days later. So it was no way in the world that he was actually in Germany. So it was a few things in his military background that we were able to show that this is a person not only that would not obey commands and would not obey court orders if given. However, he had this deceptive background and this manipulative background, and all those things were brought out in court.
Now, Anton, there were also some disturbing allegations made by his attorney about the interrogation, the amount of time he was in there, the way he was treated, being denied counsel. I'd love to get your response to that, and how do you think that might affect the proceedings going forward?
Well, here's the thing. The issue concerning how he was treated and what the officers did or did not do, those are issues for suppression. And so if they can show that the statements that he gave that in some way will show guilt towards some of these charges that are before the court were not made voluntarily or knowingly or intelligently, or if he asked for an attorney prior to those statements being made, then obviously they will not be able to come in and the court will suppress them, which we have no problem with that. Here's the problem. The problem is he was read his Miranda rights and he did waive, and all of those things were caught on video. So it's not the officer's word versus his word. It's all on video. So you can't, deceive that part. And in addition to that, any statements that he made prior, any statements that we plan to use came prior to him invoking and asking for an attorney. And I know he detailed like they had been in there for many hours, but when you go through the timeline, you can see that the majority of the statements were made somewhere in the neighborhood of 12 hours or less. in the custody of the police department and the FBI. So they have a hard hill to climb in reference to that. So we feel pretty confident that we'll survive a suppression hearing.
All right, now you talk about statements. The only statements as far as the public knows that he's made are that the child left the house in the middle of the night, and that's all he knows. Are you suggesting there are other statements here that could incriminate him in some way?
There are statements that incriminate him concerning the charges that are before the court today.
I gotcha. Okay. All right. Now, the other thing is now, right now in the investigation, I think you stated as such that he's the only person of interest in this investigation. Why is that? And do you have something that suggests he's the only one? And what's in your power to perhaps get him to talk if you believe truly that he knows something about what happened?
Now, that part, Micah, unfortunately, I cannot disclose at this time, because it's still an ongoing investigation and they are still looking into other leads involved in this case. So unfortunately, I can't go into details concerning that. But I will say, given the fact that, and this is public information already, we know that this defendant is the last person to see Cody Bigsby alive, and that's our belief. And that is the theory in which we believe that evidence supports. And so as a result of that, that's why he is a person of interest.
All right, let me bring in my investigators here, Jason Jensen and Jen Shen. Say that 4 times fast. Jason, let me start with you. You heard the situation here. They believe he is the one. He was the last person to see them alive. But there's no real trace yet of Cody. And where do they go from here in terms of trying to figure out what might have happened to him?
Right. Typically, when you're investigating the disappearance of a child, there's basically 3 categories that you look at. You're either considering it as a child abduction or a wander off, or in many cases, death and concealment. So clearly the evidence, given the fact that this was winter time, you didn't find some toddler wandering around. There wasn't footprints in the snow. So, you know, whether someone broke in the house to abduct this child, certainly Cody would have alerted somehow. Corey would have noticed somebody coming in. So clearly, I think by process of elimination, we're down to death and concealment. And it does happen. And when you have a father with a history of child neglect, it's entirely conceivable something happened while he was absent from the home or the child was out of his sight, that he panicked and did something to conceal his child.
So Anton Bell, you're fairly sure that this is not a case of an abduction, for instance, that in fact maybe the child did wander off and then was perhaps abducted. You're fairly clear that that is not an avenue you need to be chasing.
I'll just say this, Michael, the evidence does not point in that direction. The evidence points in other direction, and it has been pointing towards the father.
Jen Shen, I would imagine if there was some sort of abduction, there would be evidence of that they could find. It was a winter night. I guess there was snow on the ground. There would be places they could look to verify that. And this idea that they really have honed in on the father. I mean, talk to me about how that sort of evolves and how you eliminate these other roads, these other possibilities.
Well, when you go in to evaluate a crime scene as a scientist, you have to keep everything open and on the table. So we do not let ourselves be biased by whatever situation witnesses might have said, a suspect might have said. So you go in looking for any clue of any kind. So if you're looking at an abduction, you're right. If someone came into the house, broke into the house, went into his bedroom and took him, then you would expect to see some kind of evidence of some sort, whether that's shoe prints or tire tracks or cars coming up to the house, which you could maybe perhaps catch on video, etc., or some kind of disruption within the room itself, hairs, fibers, saliva, blood, anything. There could be so many things that could be left behind if you go in and get a child out and take the child out. Now, it can be done and has been done. There are cases where someone breaks into a house, takes out a child, and they don't have anything to lead them to a specific suspect. But if you have an absence of anything that would point to that, then you're naturally going to look at the next option, which would be that the child wandered off, or the death and concealment, which certainly does seem like the likely scenario here.
All right, so Anton Bell, I mean, you're pretty clear. It looks like you're very confident he was the last person seen with the child. So the only thing I can think of, again, you may or may not be able to answer this question, is maybe there's a witness. Do you have a witness who saw the child with him? That gives you that kind of confidence to say he's the last person seen with him?
Well, I'll say this, and this is something, again, that's public information, so I don't mind sharing it. In his statement to the police, his initial statement to the police is that he was the last person to see Cody, and that Cody woke up around 2-something in the morning and said that he wanted to go outside and play in the snow because it had snowed that weekend. And his father told him, no, go back to bed. His bedroom is upstairs. The father said that he fell asleep on the couch downstairs. So anyone who would have broken into the house, now remember, this is a military veteran of more than 20 years, a sergeant in the military. Anyone who would have broken into the home would have had to pass by their father, and not only pass by their father once, but pass by their father twice, to go upstairs and then come back with a child that does not know him, and go outside. And there were no footprints or no fresh imprints in the snow when the police and the detectives arrived on the scene. So there, and that's just a little bit of it, but just to kind of give you a little open window into some of the things that we were able to clearly see and kind of get a clear undertaking of what was going on.
All right, and finally, in the last little bit of time we have left, what's next for Corey at this point?
So we have a preliminary hearing, which is in Virginia, probable cause hearing for a determination of whether this case or charges are going to go towards the grand jury for indictments. And if they return true bills of indictments, then we will try him. And there's also the potential of new charges that may come forth as well. So right now, this is still a very fluid situation. And again, because the investigation has not ended, because we have not found Cody. So that's not going to end. That's going to continue. And so if more evidence should be uncovered, then we will at that point make decisions and determination as to how to proceed legally.
All right, let's hope we find this little boy one way or the other, bring closure, and let everyone know what might have happened here. And bring the right people to justice at the end of the day. Big thank you to Anton Bell for joining me this evening. Truly appreciate it. We really appreciate your time and hope that you'll come back and speak with us again soon. Jason Jensen, Jennifer Shen, you're going to stay with me because when we come back, it'll be time to open up our unsolved case file. And tonight, we're focusing on a cold case that goes all the way back to the 1930s. When a serial killer known as the Torso Killer tormented the city of Cleveland. We'll show you the details and ask for your help when we return.
Johnny was hitting me, and he was hitting me hard and repeatedly.
Johnny Depp versus Amber Heard.
This is going to be one of those big trials to watch.
You have these big celebrities that are going to be testifying.
Their reputations are at stake.
Johnny Depp was not successful across the pond, but he's got a second bite of the apple, this time in the United States.
Johnny Depp versus Amber Heard. Live coverage starting Monday morning at 9/8 Central on Court TV.
Welcome back. Now is the time in our show when we open up our unsolved case file. And tonight, we're taking a look at a cold case involving a serial killer who, between the years of 1934 to 1938, claimed the lives of at least 12 known victims and held the city of Cleveland in a constant state of fear. Homer Bash, a great reporter with our affiliate WEWS, has more on the story of the Torso Killer.
It is one of the darkest chapters in Cleveland history.
Town was gripped in fear.
And during that time, a serial killer stalked this city.
When the serial killers are out, they were all afraid.
A brutal killer who inspired dozens of books and blogs.
He always took the head off.
The Torso murderer claimed at least a dozen victims from 1934 to 1938.
Sometimes he dissected them more than that.
Most of the killings concentrated in an area called Kingsbury Run. These days, it's better known as the area near the flats.
He was non-discriminatory, killed black, white, women, men. Interestingly, he tended to leave the men intact. But the women he cut up in smaller pieces. Don't know why. The coroner at the time said that the murderer probably could do a better job than half of his staff in dismembering a corpse.
Out of the 12 official victims, only 2 were ever truly identified. But all of the victims had one thing in common.
People who would not be missed, people who had no identity.
In the pages of Cleveland's history, this was the city's first serial killer.
The duel, if you will, between the Torso Killer and Elliot Ness was just a fascinating bit of history.
It even brought the famed cop Elliot Ness to Cleveland to take over as public safety director. Ness, best known for taking down gangster Al Capone. But the Torso Killer wouldn't be as easy to catch.
The pressure to find someone, anyone, was so intense.
For years, the killer taunted Ness, sending letters and postcards.
He even admitted it to Elliot Ness in one of the postcards. Sort of.
This one, signed The American Sweeney. Some believe it's a reference to Sweeney Todd, a fictional serial killer in Britain.
So the fact that he would call himself the American Sweeney is the kind of joke he would love to play.
And the true nature of the Torso Killer's crimes, a mystery within a mystery.
The official police file disappeared. It's gone. No one can say exactly when or how it happened, but it's gone.
It's why so much of today's knowledge about it is reconstructed from documents and newspapers, from people's memories.
There's no sense of closure. Not for the families of the victims, but not for the public. Because we'll just never know.
But even though investigators could never claim to have caught the killer, Dr. Badal says his years of research brought him to a single conclusion.
Who do I think did it? It was Dr. Francis Edward Sweeney, a skilled surgeon who fell into alcoholism and drug addiction, lapsed into paranoid schizophrenia.
A city gripped in fear, a dozen faceless victims.
I'm 99% sure we pegged him.
And the belief that this face, this man, is Cleveland's Torso Killer.
Francis Edward Sweeney. Nothing points away from him.
And if you have any information at all, please call the Cleveland Police Crime Stoppers at 216-252-7463. Still with us, private investigator Jason Jensen and retired director of the San Diego Police Department Crime Lab, Jennifer Shen. All right, guys, this one's fascinating. I mean, whoever thought we'd be talking about a case involving Elliot Ness? And it just brings back, you know, Jack the Ripper, all these different things. Let me start with you, Jennifer. What jumps out to you about this case? For me, it's the fact that he left the men intact, but he actually cut the women up. this seems like a case that really involves a lot of psychological profiling as well.
Yeah, I would agree with that. I was thinking as I was watching that one of the things that's super fascinating to me is that if that had happened now, there would be so much evidence that you could pursue. And at that time, there really wasn't. And so what they were having to do is really focus on psychological profiles, witness testimony, just trying to build what type of person would have done this. And, to have someone who can dismember bodies well, I mean, that is a skill set that most people do not have. So getting mode, opportunity, the type of person, the psychological profile, who could have done that by, just being in that area, and then who had the skill set is really what they were going to have to go on. So quite a different investigation than it would be if it had happened today, for instance.
Absolutely, yeah, the skill set is key. I mean, I think even the medical examiner in this case said he did a better job on those bodies than half of his staff could have done. So that tells you a lot. Jason, there's that, right? But you also have this, there are these postcards that he was sending to Elliot Ness. It doesn't look like he was trying to conceal his handwriting. What about handwriting analysis? If you think it's this guy, Dr. Francis Edward Sweeney, why don't you compare some of the things that he wrote to the postcards that were written to Elliot Ness?
Mike, that is actually brilliant because of the fact that he was a physician. There's got to be some kind of writings out there. Maybe he kept journals, or there were some kind of medical files that he kept that they could actually compare the handwritings to. But to break the traditional belief that a lot of these researchers and historians believe that it was Dr. Sweeney, I think that was too easy of a target given the fact that the Jack the Ripper from the Whitechapel murders was believed to be a physician. I think it was too easy to make a physician being a scapegoat. So I actually have done my own research, and I believe this was actually the result of the mafia, the Cleveland Mafia at the time.
Really elaborate on that. The idea then I would imagine there's some connection between the victims. I don't think the police suggested that there were, but if you think it's the mafia, obviously you believe all the victims had some connection to the mafia?
No, actually, this was during the time of the Great Depression, and the shanty towns accumulated along the Cuyahoga River, and I believe that the mafia was trying to send a signal to these shanty towns and all these people that were living along the banks to move on, to leave town. And this was this form of dismemberment is actually known as communication mutilation. So it's intended to send a message, invoke fear, and get rid of these people.
That's interesting. Maybe that's why they brought in Elliot Ness, a guy who had experience with that kind of organized crime. Of course, Jen Shen, what's interesting about that is it doesn't really dovetail with the idea that these folks were cut up surgically. Where would the mafia get that kind of know-how to cut these bodies up in that way? So that would be a problem I would have. But the other thing I wanted to check with you on was, how do police files disappear? Is that curious to you?
Well, it is kind of curious. As far as the cutting up of the bodies go, I mean, it wasn't necessarily done with surgical precision. It was just done, surgeons by and large aren't cutting people's arms and legs and heads off. So, there are several types of people, like butchers, et cetera, that could be pretty proficient in removing body limbs. But again, it is a skill set that not everybody has. As far as the police file go, it's Murphy's Law. There are so many things over many, many decades that get reshuffled or moved or relocated to a new building or whatever. There are ways that could have disappeared that are completely innocuous and really speak to inattention versus something more, underhanded. So.
Fair enough. And it could have gotten lost. This was transferred over to a lot of different investigators. All right, guys, thank you so much for being on the show tonight. Jason Jensen, Jennifer Shen, always a pleasure to have you on the show, and appreciate your insights as well. It is time now, folks, for a quick break, but there is still a lot more to come. Here's a look at what's still ahead on Closing Arguments. In Anne Arundel County, Maryland, officers save an infant and a toddler from a car in a pond. We have the heroic video.
Are you able to reach that far? Got her? I got Fred. Got her.
In Minneapolis, Minnesota, 22-year-old Amir was shot and killed by police executing a no-knock warrant in February. Now officials announced there will be no charges against the officers involved.
This is a slap in the face to not only this mother and family, but to all of us. This is a slap in the face to not only this mother and family, but to all of us. And we pledge out of National Action Network at our national convention that we're going to the Justice Department to review this case. There cannot be the allowance of no-knock laws nowhere in this country, whether it is this case or whether it's Breonna Taylor It's all because we're dealing with states' rights legislation around no-knock law. This young man was in his own home, laying down with a licensed gun, and he is killed. And their defense is self-defense. How do you defend yourself in my house when you don't have a legal right? The warrant did not have his name or apartment there. What are you defending yourself against? Breaking and entering into my house? So it must be federal law. And we want her to know that we're going to stand with her and go to the Justice Department and demand they review this. This is not over.
Welcome back. That was Reverend Al Sharpton at a press conference earlier today, reacting to the news that there will be no charges filed for the death of Amir Locke. It is, of course, crime time here on Closing Arguments, so let me bring in tonight's guests. Joining me, former New York City Assistant Commissioner and former NYPD Sergeant Special Assignment, Dr. Keith Taylor. Keith served for 26 years as a public safety professional. He has supervised internal affairs, missing persons, emergency service units, and Federal Emergency Management Agency urban search and rescue teams. And he is an adjunct assistant professor in the Department of Law, Police Science, and Criminal Justice Administration at John Jay College. Also with us, a major with the Cobb County Sheriff's Office Community Engagement, Stephen Gaynor. Stephen served 28 years with the Cobb County Police Department, working in the robbery, homicide, special victims, criminal investigations, and training units. All right, gentlemen, the first story that I want to talk about tonight is this news that there will not be any charges filed against the officer who shot and killed Amir Locke. Now, you remember, Locke is the 22-year-old who was shot and killed in February while a Minneapolis SWAT team was performing a no-knock search warrant for someone else. The incident was captured on body camera video, and it was released not long after the shooting. Take a look. Now, after reviewing that video along with all the other evidence, Attorney General Keith Ellison, along with Hennepin County Attorney Mike Freeman, released this statement today. Here's what they said. There is insufficient admissible evidence to file criminal charges in this case. Specifically, the state would be unable to disprove beyond a reasonable doubt any of the elements of Minnesota's use of deadly force statute that authorizes the use of force by Officer Henneman. He goes on to say that it would be unethical for us to file charges in a case in which we know that we will not be able to prevail because the law does not support the charges. Now, while no charges are being filed for Amir's death, there are changes that are being made to the Minneapolis Police Department's policies. Yesterday, Minneapolis Mayor Jacob Frey announced that he has formalized a new policy that will take effect Friday, requiring officers to knock and wait before entering a residence. All right, gentlemen, let's dig into this right now. We see in the tape, right? You watched it. I'm sure you've seen it many times before. From your point of view, Dr. Taylor, what do you see in that video, and were all the appropriate protocols followed?
I think I see the same thing that Ellison's office saw, which was that the officers did their job. They announced they were coming in. They did what they were trained to do. And when they were presented with this threat of deadly force, they reacted to it as they had been trained to do. It's unfortunate that, the circumstances are that he did have this legal right and that he was, he did not survive this encounter. But I think that even though the officers did what they were trained to do, there's always room for improvement in how these warrants the information is collected and how the judges review. And so there's room for improvement in the process, obviously. Also, perhaps having federal standards for how these take place, how the judges review them, for instance.
Yeah, actually, we'll get to that in just a minute. Stephen Gaynor, I want to get your take on what we see on that tape, this incident as it happened. Again, as Dr. Taylor said, they can't take into account the subjective idea or thoughts of the victim, which is, he had a legal gun. Who knows what he was doing? He had it with him for whatever reason he decided to have it with him while he was asleep. But your thoughts on the fact that they're not going to file criminal charges in this case?
Well, no matter what your emotions want to charge, you have to go by the facts, as the doctor said. The fact is that they had a legal right to be there. They did have a search warrant for that residence and were looking for a murder suspect. This gentleman was not the murder suspect, but they were going in for somebody they considered to be a murder suspect. The freeze frame that you show is very convenient for them to look at and go, look, he didn't even have his finger on the trigger, but in a split second, an officer can't tell that. And they don't have the time to tell that because they might not be going home to their family if they wait to see, oh, does he have his finger on the trigger? They had to make a split-second decision. This officer testified by his statements that he felt in jeopardy of his life, and he fired. Yes, it's sad that this gentleman was killed, but the officers acted as the law allows them to act.
You know, it's interesting at that press conference, the mom basically said that this whole thing is unfair, and no one can disagree with that. But again, the question is, was it criminal? And again, they decided it wasn't. But let's talk about some of the changes now, gentlemen. There are changes to the no-knock warrant laws, and I want to get your take on it. First of all, no-knock warrants are banned except for extreme circumstances, and they cite a circumstance like a hostage situation. There's going to be civilian review of the video, which I found interesting, and they have to wait 20 seconds. They have to knock. They have to wait 20 seconds during the day before entering, 30 seconds at night before entering. Dr. Taylor, has the law gone far enough, or has it gone too far?
I think that having reasonable common sense approach changes to the current usage of no-knock warrants is appropriate. But I think it needs to be done at a national level to get all the states and all the municipalities on board to doing things in a systematic, consistent manner so that we can really get the best outcomes for all involved.
And that is exactly what the family is gunning for. You heard Reverend Sharpton saying that's their next line of attack, trying to get this on a national level, get national standards for no-knock warrants. All right, gentlemen, stand by. We're going to take a quick break. We have to squeeze one in as always. But when we come back, we're going to take a look at some video of a police rescue as officers work to save people, including an infant and a toddler, after their car crashes into a pond. You don't want to miss it. So stay right here on Court TV.
4136.
Welcome back. It is still crime time here on Closing Arguments, and our law enforcement experts, Dr. Keith Taylor and Major Stephen Gaynor, are still with us, of course. Our next story tonight comes to us from the Eagle County Police Department, where officers save a toddler and an infant from a car that crashed into a pond.
All right. Get this one. And we'll take the kid. I'm gonna close your eyes. Close your eyes. Go down the center. Now hit the center. Down low. I got it. Hold this. I'm gonna get the kid. There's two babies. All right. Give me a baby. Come on. Stay there. Don't get water. We gotta hand them off. I know it, princess. Come on, darling. I know, darling. Name me the other one. Come on, princess. Here you go. Okay. Are you able to reach that far? Got her? I got Fred. Got her. All right. Good job. Are there any others? Mama's baby? Okay. You, come on. Oh, this way. Come on. I know. Okay. I know.
Wow, kudos to those officers. And the question we would like to ask our law enforcement experts is, are officers trained in water rescues? Let me begin with you, Stephen Gaynor. I mean, again, as I said, kudos to those officers risking life and limb to save that family. Are they actually trained to do things like that?
Officers, for the most part, are not trained to do water rescues unless you're in the dive team or water rescue team. But, you know, as an officer, over the years, you run all the scenarios. You never know what scenario you're going to run into on your shift, and you're constantly running stuff through your mind. What am I going to do if this happens? What am I going to do if this happens? And who knows? These officers may have played that through their mind, but they just acted as professionals and knew exactly what to do, whether they thought about it, trained for it, or prepared for it. They knew they had to save or go to who was ever in that car, and they acted just as heroes.
Yeah, Dr. Taylor, what jumps out at me and what's most impressive is those guys stayed really calm under all that pressure, which is so important because you need to impart that to these folks who are really in duress.
Indeed, and we need to supplement that training of calmness with equipment and training for those officers. Any department that is near a pond, lake, river, stream, or ocean should have basic water rescue training for its officers, as well as equipment like personal flotation devices or throw bags with rope, so that they can act if they are the first ones at the scene and not have to wait for the specialty units to arrive, because time is precious in those situations.
Yeah, Stephen Gaynor, that's what I was going to mention. The idea that, you know, the possibility that you could sort of corral the experts in sort of water rescue. I mean, that's something that takes quite a bit of time. I mean, they pretty much had to act under these circumstances.
Oh, very much so. Very much so, Mike. The water rescues probably take an hour to 2 hours to get on scene. And we mainly use the water rescues maybe if they're stuck on a rock in the river, or if there's it's going to be a rescue or actually recovery of a body in the water. But these type of situations, you have to act appropriately as an officer on the street.
Dr. Taylor, what happens next to this family? I mean, obviously, this was traumatic. I mean, one of the most dramatic things about the video was listening to the mom. You could hear she was hyperventilating. I mean, I can't imagine what she was going through. Who knows what the kids, I mean, perhaps the infant may not understand, but the toddler as well. What do you do next with those folks?
Well, immediately, you're going to try and keep them warm and then get them medical attention. So the ambulances should be on the way. They may require some fluids depending on if it's hypothermia or other medical issues that were caused from that exposure to the water. So they will be getting help as soon as additional resources arrive.
All right, well, thankfully that turned out well. Thank you so much, Dr. Keith Taylor and Major Stephen Gaynor, for joining me this evening. We always appreciate your expertise. It is time now, folks, for a break, but don't go anywhere. I still need your help.